Good afternoon. Whatever is the correct time wherever you are, I hope you're doing well today. And if you've joined us before, welcome back. If this is your first time, welcome. Thank you for joining us, and I hope you get some good information today. So today is one of our question and answer sessions. I have received several questions in advance, and those will be answered first. But before we get started, as you know, if you've been here before, I like to begin with a quick introduction of the ICCP. Let me just share my screen real quick. Okay, so who is the ICCP? What are we? What do we do? Well, the ICCP is a professional members organization that recognizes those with the skills, qualifications, and expertise in the management of construction claims. So we have three primary objectives, and those are to establish international professional standards, to give recognition to those who have gained the appropriate knowledge, experience, and skills in the management of claims, and to help and educate those who wish to gain that experience. And why is there the need for the ICCP when there are so many construction organizations? Well, the construction claims have become a key part of the international construction industry. And claims professionals come from many backgrounds, from engineering and quantity surveying, legal, project management, etc. And at some point, they have focused on claims, but until the ICCP, there was no institute that specifically recognized those who have that specialist knowledge, experience, and the skills to be able to manage, prepare, and respond to claims to the highest levels of professionalism. Okay, I will just briefly introduce that we have an executive officer, Andy Hewitt, who will shortly be answering your questions. We have an elected president, currently Paul Gibbons. We have 3 elected fellows, although this year that will be increased to 5 due to the increased size of the ICCP. And Nina is the general manager. She's currently on maternity leave, and I'm currently filling in for her. Okay, in terms of membership, we have 3 regular levels of individual membership, each with their own criteria. And we also have 2 special levels, which are student and graduate, for those who are just either completing their first degree or have just completed their first degree. And we also have corporate membership for companies or departments that specialize in claims. Okay, and what is in it for the members? Well, we have a private members area of our website that has a knowledge bank of articles, white papers, case studies, etc. We have a collection of education, which is listings of various places around the world where people interested in studying further about claims in a face-to-face situation can go to enroll. We have a training listing, which is more CPD opportunities around the internet and in person. We have a bookshop, which does not sell books, which has reviews of the latest industry releases. We have a library of practical templates, which help our members to save time and also ensure that their claims are completed to the highest level and are done correctly, basically. We have regular CPD opportunities like this one. So this is open to the public, but only members will receive a CPD certificate. We have the ICCP Academy, which are periodic member-only training sessions, which are a bit more technical in nature. We offer savings on books and further training from Wiley Blackwell and Routledge presses, as well as our training partner Claims Class. We have a monthly member newsletter that keeps members up to date on the latest in the industry. We offer industry exposure in the form of public listing on our website. We have logos and certificates for members as a standard benefit across, I think, many organizations. We also have a private LinkedIn group where our members can discuss their claims and contracts questions with other experts in a confidential setting. And we have the optional benefit of the Register of Claims Practitioners, where members, especially those who are consultants, can list their contact details as well as their specialties in order to increase their presence on the internet. Okay, I realize that was a bit of a whirlwind tour. If you requested more information before when you register for the session, I will be emailing you with that more information, as well as the replay link. And if not, you may email me, jennifer.smith@instituteccp.com, or you may visit our website, instituteccp.com, and you can get more information there. All right, and with that, we will head over to our regularly scheduled program, the questions. And I'm not sure if Andy is going to need a share screen. So just give me 1 second.
No, Jen, I don't need to share the screen.
Excellent. Then I will stop looking for where that setting is. I could have prepared that in advance. I'm sorry. I was having some troubles with Zoom this morning, so forgive me. All right, Andy, are you ready to jump in with the questions?
I am indeed, and thank you. I should get the video on. Thank you, Jen, for your introduction. I realise that you are jet lagged for everybody else's benefit. Jen's just returned from a visit to the United States, to the UK, yeah, the last thing you want when you're feeling a bit like that is the software to be playing up, and Zoom was giving problems as well. Anyway, straight into the questions. Firstly, welcome to everybody, and especially those who are ICCP members. As Jen's already explained, this event is open to non-ICCP members, and the reason we do this is firstly to share knowledge, and secondly, it's to give you some idea of the benefits of becoming an ICCP member will bring to you. So I do urge you to have a look at the website, and if you're involved in claims and management of claims, responding to claims, please, consider joining us, because there are an awful lot of benefits to becoming a member. And depending on where you live in the world, if you live in certain countries, we do membership and the application fees at a reduced rate to help people who may not be on the same sort of income as people are in the, let's say, the Western world. Anyway, on to the questions. We had some pre-submitted questions, which I will deal with. And if we have time, I'll deal with any questions that anybody wants to raise today by asking them in the is it the chat box or the Q&A?
Let me interrupt. Please put them in the Q&A box. Sometimes things do get lost in the chat box.
Yeah.
But I will definitely see them in the Q&A box.
We'll see what we have time for anyway, but please feel free to put your questions in, and bear in mind that there's a difference between questions asked today that I've got to answer on the fly, and questions that have been pre-submitted that I've had a chance to consider my answer to. So let's start off with Aninda Mitra, and the question is the FIDIC 2017 Red Book still biased to the employer like the former versions as far as practical risk management is concerned? Well, I have to take issue with this, Anindra. One of the principles of all the FIDIC contracts is that they are fair to both parties. The allocation of, having said that, the allocation of risk, however, is not the same through all of the different forms of contract. The Red Book and the Yellow Book is purposely a balanced contract in terms of risk management. In other words, the contractor and the employer share the risks that could happen on a construction project fairly equally, based on who is best managed to control the risk, who is best able to foresee the risk, and who is best able to, or fairly able to, pay for any risk that occurs. A contract like the Silver Book is specifically I wouldn't say biased, but has more risk which is put onto the contractor. And this is because the employer in a Silverbook contract, it's a turnkey contract, and it's specifically designed for the sort of employer who will accept that he will need to pay more for his project if the contractor accepts a lot of the risks or some of the risks that it would otherwise be allocated to the employer under red or yellow book. Now, this is purposely set out by FIDIC to be like this because there is an appetite for some employers to say, look, I'm prepared to pay more for my project, but I want a pretty good idea that it's going to be completed on time and it's going to come back to my budget. Now, if you're going to go with that attitude, you must accept that the contractor will price the additional risk that he accepts under a silver book and include some insurance money, if you like, within his price. So I would not say that it's biased towards the employer, Anindra. Maybe you are not looking at a standard version of FIDIC. Maybe you're looking at one that's been butchered by the employer or the engineer to shift the balance of risk allocated by FIDIC and move some of those risks from the employer to the contractor. So I do hope that answers your question. Anindra, I know you submitted a page full of information and attachments. That is not the forum for this. I can't go through in a brief webinar like this and look at all those things. So I hope that at least has answered your main question. Jaffa Ismail, a familiar name, an ICCP member. Two questions from Jaffa. Hi, Jaffa. What is the appropriate method of incorporating and implementing a hybrid dispute resolution, such as mediation, arbitration, and a multi-tiered dispute resolution, mediation, expert determination, adjudication, arbitration, in the resolution mechanism in the FIDIC contracts, and the role of the engineer and other external parties? Well, it's like, well, first of all, I would question when there's a very, very good clause 21, which deals with dispute resolution through the DAAB, the Dispute Avoidance and Adjudication Board. I think that the mechanism included in the standard FIDIC contract in 2017 is an excellent way of resolving disputes that may occur, and in fact avoiding disputes. Why you would want to change that, I really don't know. But if you are insisting on changing it, you would need to rewrite the majority of clause 21, redraft it. And as with any form of redrafting on a contract, redrafting of clauses, this needs to be done very, very carefully by somebody who firstly knows what they are talking about, secondly has an excellent command of English language, and it needs to be checked by a lawyer to make sure it is legally compliant. So that applies to any change to any form of contract. So question 2 from Jaffa. What are the common areas of deficiencies found in FIDIC 2017 and suggested improvements? To be honest, Jaffa, and a lot of people criticised FIDIC 2017 when it first came out, and they said it will require an awful lot of additional contract administration. I initially thought that myself, because the number of clauses has more or less remained the same, but the number of words in the contract is significantly more. One webinar I went on, the presenter weighed both forms of contracts, and the 2017 weighed a lot more than the 2019 version. Now, when I got into it and started writing books about it, so I really had to get into the nitty-gritty of it, I realized that 2017 doesn't require an awful lot of additional contract administration than it did in 2019. But what FIDIC saw was that the parties to the contract, and I've got to include the engineer here, were not performing their obligations or were not performing in a professional manner the things that they should have done in 2019. The contract administration was often very, very poor. So what FIDIC's done now is put things that should have been done as a matter of good practice and elevated them to obligations. And if there is an obligation that is not performed by one of the parties, and this is the significant difference, there is now usually a default position, a deeming provision. So, for example, under FIDIC 2019, once the contractor had submitted a claim, the engineer had to respond to that claim within 42 days. If he didn't respond to the claim within 42 days, nothing happened. So the contractor is then stuck, he's prepared his claim, he's submitted it, and the engineers virtually ignored it. And they can ignore it and ignore it and ignore it till the end of the project, and then try and negotiate. FIDIC 2017 says that if the engineer doesn't go through a sequence of attempting to agree the claim, and then if agreement is not possible to issue a determination on the claim, within a certain period, the claim is deemed to be rejected. So that gives the contractor the pathway to refer the matter of a rejected claim because of non-response to the DAAB for a decision. So there he would get his claim resolved. So that's an example of how I think that really 2017 just makes things obligations that should have been done as a matter of good practice in 2017. In 1999. So, going back to Jaffa's question, what are the common areas of deficiencies found in 2017? I've only noticed one, Jaffa, and that is, as I've just explained, in 2019, the contractor submits a claim. The engineer is required to respond to a claim within 42 days of receipt of the claim. Once he's responded to the claim, he is then required to attempt to reach agreement within the parties, and if that's not possible, to proceed with a formal determination. In 2017, the contractor submits the claim, and there is no requirement for the engineer to respond to that claim. He just has to then go on to attempt to reach agreement, and if that's not possible, issue a determination. Now, to my mind, this is a big hole in the procedure. So think about it from the employer's point of view. We do have some very sophisticated employers, particularly developers, who amongst their team have got a very good handle on contractual matters, claims, etc. So they are able, if you like, to fight their own corner. And we actually find that in reality, very often the employer is hands-on involved in responding to claims, and often guides the engineers to how they should respond, which is not exactly correct, but that's the real world. But if you look at it from the point of view of an unsophisticated employer, I just want something building. I've got no idea of the construction industry. I don't understand design. I don't understand construction contracts. I am employing my engineer to advise me. So for a claim to be submitted against me, and then the engineer to sit down with me and want me to agree, or attempt to agree something with the contractor, when I know nothing about the industry, nothing about the claim, nothing about the event, how can I agree that when I've got no knowledge? I'm ignorant on these subjects. I need my engineer to advise me. So because this is, I think, a very essential part of the procedure has been omitted from 2017, I think it will cause problems because the employer needs the support, the advice of the engineer, and that was previously provided by requiring the engineer to respond to the claim and the actual fact to act neutrally whilst he was doing so. So that's my big problem. In other cases, Jaffa, I don't really see any areas of deficiencies. There's one or two things that could be a little bit grey, but I think in general it's a great improvement on 2019. And the reason for this is that FIDIC wasn't, when they were preparing FIDIC 2017, looked at what was happening in the industry. They looked at things that were causing disputes and arbitrations, etc., on a regular basis, and then took the necessary steps to close those gaps, to clarify things, to reword clauses to provide clarity and to provide, and there's a lot more procedures included as a matter of contract included in 2017. So if this happens, the parties must adopt this step-by-step approach to managing them. And these now have become obligations. And as I've said, if either party doesn't perform those obligations, there will be a deeming provision to give some further power or a right to the other party. So I hope that answers your questions, Jaffa. On to Wymal or Wimal Gamlath. Wymal says, in the FIDIC 1999 Red Book, subclause 13.3 variation for procedure says, each instruction to execute a variation with any requirement for the recording of costs shall be issued by the engineer to the contractor, who shall acknowledge receipt. However, in FIDIC 2017 Red Book, we do not see such a statement. Is there any specific reason for deletion? I don't know. I didn't draft it, but in 2017, subclause 13.3 variation by includes two separate procedures. Firstly is variation by instruction, whereby the engineer can simply instruct the contractor to carry out a variation, probably accompanied by some revised drawings, etc. And then the contractor, with a certain time, has to give proposals or to evaluate the variation. So in simple terms, would price the variation and submit it to the engineer. He's also got the opportunity at that time to demonstrate any extension of time that the contractor will be entitled to because of the variation, and include any costs as a result of the extension of time. So we could have in the contractor's proposal, this is the measured work evaluated at the contract rates and prices, or in fact, if necessary, under clause 12, at different rates and prices, if there's a reason for that. This includes our extension of time requirements or assessment, and this includes additional costs incurred by the extension of time. Submits that to the engineer, and then the engineer is obliged then to attempt to reach agreement between the contractor and the employer, and if not possible, issue a determination. So that's variation by instruction. We also have in 2017 variation by request for a proposal. So it's very, very similar. It's just the timing of the way that the contractor evaluates and submits the proposal to the engineer. In this case, the engineer doesn't instruct the variation at this point, but asks the contractor to submit a proposal, which would be pretty much the same as if the instruction had been given by, or the variation being instructed, and then the contractor submits this information retrospectively. The difference is that in this case, by a variation by request for a proposal, the contractor submits the proposal, then the engineer looks at it and says, okay, I'm happy with that, go ahead. Or no, we don't want to do that, don't go ahead. Or I'm happy with that, but I have these comments. I don't think your extension of time should be this amount, it should be that amount, or the way that you measured it is correct, and it should be this way. So it can be, the engineer can give comments, but then would instruct the contractor to proceed with the variation, or in fact not. Now, at this point, at either point, it would be sensible for the engineer to say, some of this work is going to be really difficult to evaluate by measurement and evaluation using the contract rates and prices. Maybe we need to record the costs. Maybe you need to record the costs for any prolongation. Maybe you need to record the costs for additional mobilisation, etc. Why it's not in 2017, I don't know. I think it would be a good thing, but we have to live with what we've got. But again, this is a way that the procedure for variations, I think, has been strengthened in 2017. In 2019, there was always a problem whereby, again, the engineer could give an instruction to carry out a variation or request a proposal, but there was no mechanism. If the engineer gave a construction, there was no mechanism for the contractor to receive prolongation costs. Yes, he could claim for the additional work, measure that and evaluate it at the contract rates and prices. Yes, he could claim for an extension of time under clause 8.4, but where does he claim for his prolongation costs? It was a hole in 1999 that's now been fixed, because this now, the clause 13.3 now allows the contractor to submit a proposal either retrospectively or in advance for everything that he thinks is due to in terms of time or money because of that variation instruction. Okay, a long-winded answer there, but is there any specific reason for the reason the engineer would not give an instruction for recording of costs? I think it's sort of implied, but yeah, I agree it would be clearer if that was included. Question 2 from Wymal. We understand that there are several types of claims, such as contractual claims, extra contractual claims, quantum merit claims, ex gratia claims, etc., existence in the industry. Does the engineer have the right to determine all types of the claims, or he can determine only contractual claims? I've got to disagree with you here, Wymal. These are just terms which are used to describe different types of claim. So let's go back to what is a claim. A claim is just an assertion of a party's right, either the contractor or the employer, to compensation because of an event. So we're asking for something, and in our industry, it's either additional time, it's additional money, or it's both time and money. So whether you call that a contractual claim, an extra contractual claim, all these things, they are still claims. We're just asking for to be compensated for something that the contract, or sometimes the law, says we are entitled to. So it's asking for something that is ours anyway. So you might put names on the different types of claim, but they are still claims. So as far as FIDIC is concerned, they don't have all these different labels. They are still just a request for additional time or money. So does the engineer have the right to determine all types of claims? Well, the contract says that if either the employer or the contractor considers them entitled to something, they must submit a claim, and the engineer must go through the procedure of attempting to agree the claim, or if not possible, to determine the claim. What type of claim it's called doesn't really matter. It's still a claim. And then question 3 from Wymal. What is the duty of the DB member, I assume dispute board member, during the period of construction? Well, the DAAB, let's clarify here, that FIDIC calls it the Dispute Avoidance and Adjudication Board, DARB. And the responsibilities of the single member or the 3 members are to attend meetings, to keep abreast on what's happening on the contract by site visits and by reading reports, and I would say always the monthly progress report, keeping a tab on the claims that have been submitted and responded to, etc. To make site visits, to talk to the employer and the contractor during those site visits, and to provide advice if that's requested by the parties on matters. This is the dispute avoidance part of the agreement, and to decide on disputes that are referred to them by either party. So that, in a nutshell, it's quite a bit more involved than that, are their responsibilities during the construction period. Well, Mel goes on to ask, can the DAEB member act as a member of the project team and provide advice to the project team to avoid any disputes? I'm not quite sure of your wording here. Can they act as and I'm going to call the DAEB, it's a they, let's assume it's a 3-person board. Can they act as a member of the project team? Not in all cases. He can't just be on site and willy-nilly give advice to people and get involved in the running of the project, because the DAEB member is impartial, and they have to remain impartial, and they have to be seen to be impartial. But one of the advantages of the DAEB agreement is that the board, if you like, do become part of the project team, but they have specific restrictions. They can't just be on site and be giving advice and taking part in the management of the project. But part of the avoidance responsibilities is during the site visits, we can say, okay, this claim's been going on for some time now, and we're not quite sure what's happening here. Would you like to talk to us about it? Would you like us to give you any advice on it? Or we can see there's a contention from looking at the correspondence arising over this event. Can we advise you on it? And the board then becomes part of the team, if you like, because they're there to serve the project, but in a certain specific way, in a neutral, unbiased way. And yes, they can provide advice to the project team to avoid disputes. Now, let's say that the employer or the engineer and the contractor, something's happened and the contractor thinks, I think this gives me entitlement to a claim. And the engineer, usual default position, will say, no, there's no entitlement to a claim for that. That's not a variation or whatever. And let's just say it's a genuine contention here. It's not got nasty. It's not elevated to a dispute. But what the contractor and the engineer / employer can do is say, well, let's go and ask the 3 wise men, the DAAB. That's what they're here to do. And jointly go to the 3 wise men and say, look, this has happened. I think it's, from the contractor's point of view, I think this is a variation and I should be paid extra money for it. The employer doesn't think it's a variation and it should be included in my price anyway. Please tell us what you think, 3 wise men. So the 3 wise men go away, they talk about it, they examine it, they may ask other questions and ask for additional information, and then they will come back and say, having investigated the matter, we think that I think you would take that as being good advice, because it is through 3 wise men, because they've been employed as a DAAB because of their expertise, and they are required to be neutral and to give this sort of advice and any decisions under the terms of the contract. So if the answer is no, we don't think it's a claim, the contractor can go, well, okay, I've got to accept this advice. I won't pursue it any further. If they say, yes, it is a claim, well, the engineer's got to say, okay, well, the 3 wise men have said it's a claim. I've got to look at this when the contractor submits the claim in a different way, let's say. So, yes, they are there to resolve disputes, but also to help both parties to resolve disputes. And finally, from another question number 4, does the employer require to give notice under subclause 2.5 employer's claims to make a claim under the performance bond? There is no 2.5, or there is a 2.5 in 2017, but it's nothing to do with employer's claims. Clause 2.5 is site data and items of reference. In 1999, there was a 2.5 employers' claims, but in 2017, both contractors and employers' claims are dealt with under clause 20, and the employers has to go through exactly the same procedures when claiming from the contractor as the contractor, claiming from the contractor as the contractor does. So it's the same procedure and not a separate clause for if the employer wishes to make a claim. Claims under the performance bond, for that you need to look under clause 4.2, the performance security clause. And that gives a list of reasons why the employer may claim under the security. And this is generally for defaults by the contractor. Whether he needs to give notice, to be honest, I didn't check that, but have a look at clause 4.2, performance security, and that will tell you whether the employer needs to give a notice to the contractor before making a claim. In 1999, I don't think he had to, but again, there was a restriction on the sort of things, the sort of reasons he could make any claim under the performance security. So that is a list of, that is my pre-submitted questions. We're now 40 minutes into the webinar, the 30-minute webinar. Do you have any nuggets in the Q&A for me, Jen, just for another 5 minutes to give some other people a bit of a chance?
Okay, yeah, Paul Mallon had submitted a question, but I was awaiting some more clarification, which never came in. So maybe we can discuss that at a future one. I got an email about 5 minutes before we began, which I only saw because I was having trouble with Zoom. But Chandra asks, in a contract under FIDIC 99, if it's proven that the engineer or employer failed to grant a legitimately due extension of time under a valid notice towards the end of the period for completion, and that the time for completion elapsed without an extension of time, whether it could be treated as a case of time at large without an argument.
Yeah, generally, if the contractor's got good reason for an extension of time to be awarded, and then we then exceed the prevailing time for completion, time would be at large, and then we get into all sorts of legal complicated arguments, etc. Very often, the reason that the time becomes at large is because the contractors do not submit their claims in a timely manner. They wait until the end of the project, and they submit them at the end of the project, and that gives very little time for the engineer to respond. Sometimes the engineers just don't respond. Well, in 2017, as we've already talked about, that can now be treated as a rejection, and the employer, the contractor, can refer the matter to the DAAB. So that's another reason that 2017 has improved things. I've opened the Q&A box, Jen.
Are you going to cherry pick the ones you want?
Yeah,
while you're looking for a good one, I'll answer Abdullah's question. Can we see or receive the queries referred to by Andy? The answer is yes, but if you watch the replay, the questions will be written on the screen. If you would like me to email you the questions, then please send me an email and ask for the questions, and I'll send them to you.
Right, anonymous attendee, good morning. Every FIDIC contract that I've worked on has had the DAAB replaced with an engineer's decision. What are your thoughts on this? Absolutely terrible. The DAB or DAAB is there for a reason. The cost of employing the three wise men in terms of the overall project cost is so small, it's just sensible insurance. And generally, any employer engineer that wants to remove the DAB clause, I would be suspicious of, because basically they are firstly worried that the DAB may expose their own shortcomings, and secondly, it will reduce their ability to bully the contractor without a DAB. So in my case, always have a DAB. They're there for a reason, and it works. Statistics show that they work. Olawale, 2019, you mean 1999. My apologies if my mouth got confused. Yes, I am talking about FIDIC 1999. Anonymous attendee, what is your view with respect to claim for suspension and disruption under FIDIC 2017? The same as any other claim. If you have a claim, if suspension and or disruption has caused you to a delay or to incur additional costs, submit your claim. Another anonymous attendee: what potential prolongation costs would the contractor incur in the event of a variation works with similar work items in the contract? Okay, this becomes particularly ambiguous when evaluating the works using contract rates, raising concerns about potential double payments for the contractor. Clarity hinges on the necessity to recalibrate the rates to avoid any such duplication of payment. I'm sorry, I don't quite understand that question, and time doesn't give me, is not on my side to delve into it. Sorry, maybe if we've got a variation and the variation causes an extension of time, we've got two things. We've got the evaluation of the additional or changed works, which can generally be done using measurement and the evaluation of the bill rates and prices, but we've still got the prolongation cost because the variation has delayed the time for completion. You need to evaluate your prolongation costs separately and maybe put two claims in. This is for the changed works, and then a separate claim for the prolongation associated with the extension of time. Maybe you're overcomplicating things and wanting to put your prolongation costs into the rates and prices. That is just making life difficult for yourself. Keep things simple. One claim for the works, another claim for the prolongation costs. Lalith, in a construction project, if there is an employer's claim notice by the engineer against the contractor, what is the contractor's role? Well, the contractor, the engineer would not submit a contractor's claim. The engineer would not submit an employer's claim. The engineer needs to submit that to the engineer himself. The engineer's job then is to attempt to reach agreement on that claim between the contractor and the employer. So the contractor's role is to take part in that agreement process and say, yes, I agree with the employer's claim, or no, I don't agree with it because. So it's part of the resolution process. And Lalith again, how to respond employer's claim by the contractor. Look at clause 20. It will tell you what the procedure is. If you don't agree with the claim, you don't have to agree with it. But of course, in any form of contract, form of contention or disagreement, it's not just a case of saying, I don't agree, which let's face it, employers often say, don't they? I don't agree with this claim, full stop. No, you've got to give reasons, and those reasons have got to be set out clearly. And I don't agree because there is no clause that gives entitlement for X to make this claim, or I don't agree because the delay analysis to demonstrate the extension of time has not been done correctly. So it's the because I don't agree that's always important. So that's it, a quick whiz through the Q&A, and I think we could call it quits, Jen.
All right. Yeah. Thank you to everybody. I am sorry, Paul, that I wasn't able to get your discussion points discussed. I think it was an interesting topic, but a little bit of clarification. So we can maybe set that up for another session. And everyone else, thank you so much for joining us. I hope you found this interesting and informative. And as usual, the replay will be posted. Give me a couple of days to get out the CPD certificates and the information and get the replay posted on the website and our YouTube channel. And with that, I will, we have one thing in here. Oh, thank you. Well, you are very welcome. Thank you for attending. All right. And with that, I will say goodbye. Thank you, everybody. See you next time. Bye.
Goodbye.